Welcome to our weekly weekend venued broadcast here on the stations of Civic Media throughout the state of Wisconsin and yes, beyond Wisconsin too. My name is Jim Santelle and I am your on-air host for the next 2 hours here on our Civic Media broadcast. We call it Amicus, a law review. As you know well, this weekend venued weekly review takes its name from our adopted and our embraced commission here on these stations of Civic Media. That's to conduct a review, an examination, some analysis, some deliberation of the recent news of our times in our state, in our nation, and in our world, areas of law and government, and the aspiration for justice. Amicus, as you know now, a legal term. It's derived from the Latin. It is meant to describe a friend, thus the core word there, ami, A-M-I, an individual or an organization that assists and promotes in some kind of understanding, some sort of appreciation of the relevant issues or of attention or some resolution by some entity, some court, some organization of some kind. And in that effort, that understanding, that appreciation, promoting all of that, focusing on those relevant issues, we offer information, some insight, some perspective, and maybe even some expertise along the way. That is indeed all our mission. That's our purpose. That's our goal on this weekly weekend broadcast that, yes, indeed, also involves you every weekend. And you are our listeners. We value and cherish your contributions to Amicus, a law review every single weekend. We encourage you to call in at 844-967-2789. That number, once again, is 844-967-2789. Or you can also text us. You can drop a note into our feed on the Civic Media app. And Max is my spectacular producer here in the studios of Civic Media. And together we're going to get your inquiries and your questions about the rule of law related topics of our day, the justice related issues, your inquiries, the things that have you puzzled in the course of our syllabus. And what is our syllabus for this weekend, this Memorial Day weekend, about which we will talk later as well? What is our agenda? What is our discussion set of topics? Well, that agenda for this edition of Amicus, a law review, includes a number of late-breaking stories, but also things promised from our previous broadcast. Yes, that's right. At the end of our broadcast last weekend, I promised that we would take up and review again the issues related to Associate Justice Sam Alito. We began with some discussion last week about this flag issue, this upside-down flag issue, aggravated just this past week. Yes, there's more news in connection with a second flag flying at a second home of his. We'll talk about the news story there. We're going to talk about the ethics aspects of that at the top of this, our first hour of this weekend broadcast. And then we're also going to go beyond that to talk about what I'm going to describe to all of you as the cynicism and the contempt of this Associate Justice for the basic trappings of our government, of institutions like voting and polling, institutions like, yes, the Supreme Court, the grand jury process, the process of jurors coming in and making determinations, prosecutors, judges, the very systems and organizations that he is supposed to and has taken an oath to support and defend. We'll talk about all of that. We'll talk about that not only in connection with these flags, which is critical, but we're going to go back and talk about other things that Associate Justice Sam Alito has written into the law of our nation. We're going to go back to a case called Brnovich and a major case, a decision by the Supreme Court. under the Voting Rights Act. We're going to talk also about some of the language he used in overturning Roe versus Wade a couple of years ago in a case called Dobbs. And then we're going to especially focus on something he did just 1 month ago, and that is his examination of the lawyers during the course of the oral argument on the challenge by Donald Trump to the prosecution against him in Washington, D.C. This challenge based upon the notion, the silly, the frivolous, the absolutely absurd and dangerous notion that somehow a chief executive in our nation has immunity. I'm going to talk about what the Associate Justice, his name once again, Sam Alito, said in response to an engagement with the attorney for the government having to do with the legitimacy of the basic trappings of our country. The basic trappings of government and operation, including, again, the processes inside the court system, which he himself is not only a part of, but stands virtually at the top of. We're going to talk about Sam Alito and what has to happen. We're going to talk about what has happened just in the past couple of days, the response by Congress and indeed by the chair of the Senate Judiciary Committee. His name is Dick Durbin. We'll talk about what he has invited to happen, which is a meeting. You can tell by the way I describe that that is plainly not enough, but some response by the Congress to what has happened in connection with the flags. My advocacy this morning on Amicus is there are issues much beyond the flag that reveal an Associate Justice who does in fact have contempt, hugely cynical for the very trappings of our government, and that Sam Alito should no longer be an Associate Justice of our Supreme Court, deciding cases on the very issues that he is apparently advocating for through those flags. But beyond that, exhibiting on a routine basis in his writings and the things that he says, so much contempt, so much cynicism that a Supreme Court justice can no longer impartially and without bias rule on the facts and the law of our nation. Sam Alito should no longer be on the Supreme Court. That is the advocacy which you will hear from me this weekend as we go forward on Amicus, a law review. We have also got another connection with Sam Alito, which we're going to chat about this weekend, and that is one of the major decisions issued by the Supreme Court just this past week. Yes, that's right. We are now in that period about which we have spoken a lot on this weekend broadcast. That is this time period in late May into June, maybe into July as well, but certainly the next 4 or 5, maybe 6 weeks at the outside, in which the Supreme Court, the United States Supreme Court, including Samuel Alito, among the members of 9 altogether there, Sam Alito and others, issuing opinions in major cases having to do with social media and guns. And yes, Trump immunity and another issue related to the legitimacy of the indictment against him. All those kinds of cases and more, especially involving agency deference, all those cases to be decided in the weeks just ahead, thus animating a lot of our future syllabuses and agendas on this program, especially this weekend, focusing on this major gerrymandering voting rights case under the Equal Protection Clause of the Constitution of the United States of America, coming out of South Carolina and finding that the decision by the legislature there to gerrymander a particular district, it's the first district, it's along the coastline there in South Carolina, that particular district was not gerrymandered for racial purposes, but rather for partisan political purposes, something that, again, in the jurisprudence of our nation is permitted now. And based upon that, permitting this particular district to go ahead and basically disenfranchise significant portions of the population, the Black population in South Carolina, in such a way that the Equal Protection Clause, according to the Supreme Court, the majority, and yes, indeed, Sam Alito, is not offended by that provision in our Constitution, not in violation of the Equal Protection Clause. Nonetheless, we're going to talk a lot about that decision by the Supreme Court. It is undeniably a loss when it comes to identifying voting and the possibility, the prospects for always ensuring that people who are legitimately voting have the opportunity to do so and to elect people of their choosing. This is a setback, undeniably, in the wake of a couple of other recent decisions indicating that maybe, just maybe, the Supreme Court might be inclined to encourage and advance the interests of voting rights. This past week in the South Carolina case, which we will talk about in some detail, in great detail. We're going to go through what Sam Alito wrote on behalf of the 6-member majority in that case, talk about his findings, talk about his basically substituting his in a what's called a de novo review of what happened below, substituting his view of the evidence and going into great detail in a nearly 40-page opinion about why it is the lower courts that had found that indeed there was inappropriate, unconstitutional gerrymandering that disenfranchises a major portion of the population there. We're going to talk about the basis for that. And then we're also going to talk about 2 other significant aspects that also have to be discussed in the discussion groups of America across our nation, including right here in Wisconsin and in our neighboring states and listening states throughout the nation. And that is an incredible concurrence, if you will, of another Associate Justice. His name, of course, he is Clarence Thomas. We have heard from him before. Invoking principles in his concurrence. Actually, it's partially a dissent. He says, I disagree with a portion of the majority opinion, but the most significant thing coming out of his writing that accompanies this major decision, again, finding no gerrymandering, no racial problem in South Carolina, is that he doubts now. He doubts now the efficacy of efforts in the wake of Brown versus Board of Education, 1954, the efforts to enforce that. He suggests that we should turn back the clock. And we'll read from exactly what he says in the course of his opinion. And then very significantly, we're going to spend a lot of time talking about the major dissent written by Elena Kagan, but also joined in by the 2 other justices who, again, typically fall on that side of the jurisprudential aisle. That is Ketanji Brown Jackson and, of course, Sonia Sotomayor. A compelling piece of writing that takes apart the majority opinion, then says, you know what? The lower courts got it right. And we're going to talk this weekend about a concept called clear error analysis. Clear error analysis, in which the courts, traditionally appellate courts, defer to a lower court's finding, a lower court that has had the benefit of hearing the witnesses and reviewing the documents, doing all the things as happened here, an extensive trial. We're going to talk about that as well, and the compelling nature of what Elena Kagan wrote in response, in strong objection, in dissent to this major opinion. And then we're also going to talk about what happened in Louisiana this past week. That is the decision by the legislature there to effectively classify mifepristone as a regulated or controlled substance. We're going to talk about why that's so important, even as the Supreme Court, among the cases coming up, has that very issue also on its docket. All of that coming up on our weekend broadcast here on Amicus, a law review, the broadcast stations of Civic Media. Stay with me, stay with Max for all of that discussion coming up.
I went to play the intro at the start of the show and play it. Cartwell wouldn't play it again.
That's I know it's not you. We'll figure that out. Yeah, if last again, I know it was an issue last, but the second hour last time you found it, so it's got to be out there.
Well, no, it's there.
Okay.
When I click it, it doesn't start.
Not a big deal.
Because the Play Cartwell thing is online, not downloaded.
Okay.
So it's not it's not local.
So something is about this. So we'll have Luke reload it, right? Because I know it's there, right? It's reused in the past. So that's fine. I'll just announce it again at the top of the second hour. That's fine. The music sounds a little bit better already, so good. This is Amicus, a law review. My name is Jim Santelle. I'm your host this hour and next hour on our weekend review of justice-related issues. We are beginning at the top of our expansive but achievable syllabus on this weekend broadcast, talking about Samuel Alito. The entire nation is talking about Samuel Alito. It is plainly relevant to an understanding not only of our Supreme Court, the work that it does, but his involvement in some major decisions pending right now on the docket of the Supreme Court to be decided in the next 5 to 6 weeks. That's arguably the narrow reason why these flags that are flying over his home in Alexandria, Virginia, and yet at his vacation home as well, that's why they are so very important. Going to be spending some time as well chatting beyond the flags about the other things that this Associate Justice has said and done in recent years that tell us an awful lot about him and reveal his incapacity to serve any further as a Supreme Court Justice on our highest court. Let us go back and put the predicates, the factual predicates for this all back in place. We know well that Sam Alito, along with his wife, have a home. Their principal home is in Alexandria, Virginia. It is just across the river from where the Associate Justice works with the Chief Justice and 7 others on the Supreme Court. He lives there with his wife, and we know that the upside down flag, the United States flag, was flying there on January 17th of 2021. Some neighbors have provided copies of that photograph to the New York Times, which has, of course, been producing that picture, sending it around in other media outlets throughout the past couple of weeks. The image is stunning, principally because by showing that upside down flag, the United States flag, it is a signal that the people who are flagging it, putting it up there, that people who are promoting this concept are indeed supportive of Donald Trump. The supporters of his who have been arguing through the use of that flag, and obviously in many other ways, much beyond that, that the voting that resulted in the election of Joe Biden and the rejection of Donald Trump's candidacy was fraudulent. And that upside down flag, the United States flag, is being viewed as, and has been adopted by those people as the Stop the Steal symbol on display, suggesting again that the 2020 election was stolen, a position that we know is untrue. It is factually untrue. More than 60 courts have made that determination. The flag, again, which was flying in above the Associate Justice's home for several days, perhaps, on January 17th of 2021, sometime right before the inauguration of President Joe Biden, shortly after the insurrection at the Capitol, and again, even at that time, while the Supreme Court was contending with whether to hear a 2020 election case, all of that focusing on what Sam Alito is doing. Now, as we said last time, as you have heard, the Associate Justice has denied any complicity in this, said, nope, this is not me. He said, I had no involvement whatsoever in the flying of the upside down flag. It was briefly placed by Mrs. Alito, his spouse, in response to a neighbor's use of objectionable and personally insulting language on yard signs. So what does that tell us? It tells us that we know that he understands that the upside down flag should not have been there. That's my wife, he says. That's what she did. I have no involvement in that, because he understands implicitly by sending that message, he is supporting a partisan view, a political view, a view, frankly, that is completely factually unsupported, that indeed the 2020 election was stolen, that the Stop the Steal people on January 6th, and even since that time, are somehow right when in fact they are wrong, and that partisan view, that political view that others may have in the United States, even though, again, it is unsupported, it is a frivolous and completely unfounded position to take. Nonetheless, if you're in the private sector and want to maintain that, you've got that right under our First Amendment to do it. As an Associate Justice of the Supreme Court, where you're deciding cases having to do with the 2020 election, having to do with the insurrection on January 6th of 2021, When you do that, you not only compromise your impartiality, but you send a message to the entire world, the entire nation, all the people looking at the Supreme Court as this bastion of non-bias and of impartial review of issues, that you in fact are biased, that you've got this presupposition that the people who advocate that the 2020 election was stolen are right. You support them by virtue of putting that "Stop the Steal" sign in your yard, that upside down flag. Indeed, we know. We know that the upside down flag for many, many years was used as a symbol of emergency and distress. It was first used as a military SOS. Historians will confirm all of that. But in recent decades, once again, it has increasingly been used as a political protest symbol, and a very controversial one most recently, because of this continuing sense that somehow the 2020 election was stolen, being used as a symbol that indeed the stealing of the election has to be stopped and overturned. Sam Alito basically now endorsing that position, even as he is deciding past cases, and as we know, present cases, one of them involving whether or not Donald Trump should be immune for his part in what happened on January 6th. Also, this other related charge under Section 1512 of Title 18, whether or not that statute can form a basis for those who rioted on the Capitol grounds on that day. That statute also the predicate for 2 of the 4 charges against Donald Trump. All those issues pending before the Supreme Court right now, pending before, among others, Samuel Alito. Now, beyond the flying of that flag upside down in Alexandria, Virginia, just this past week, we got more. Because in the wake of our program, our broadcast last weekend, we got even more information that last summer, 2 years after the upside down flag was flown outside his Virginia home, Sam Alito, using another provocative symbol, was also sending the same kinds of messages. This time, it was something called the Appeal to Heaven flag, which, like the United States inverted flag, was carried by rioters at the Capitol on January 6th. It's also known as the Pine Tree flag, dates back to the Revolutionary War, but fell into obscurity once again until recent years, once again resurrected as a symbol of support for former President Donald Trump and a religious strand of the Stop the Steal campaign for this push, this initiative to remake American government in Christian terms, advocated by many Christian nationalists. Photographs, again, from the New York Times, along with accounts of neighbors from that area, passersby in the area. The Alito home on a Long Beach island in July and September of 2023, less than a year ago. All of that show that symbol, once again, that provocative flag being flown at the home of Sam Alito, once again underscoring that maybe it wasn't just his wife, and that this notion of pointing to your wife and suggesting that you know it's wrong, well, he's gone quiet. He's gone quiet on this because now we've got a second indication of his bias. And all of that, again, in the midst of this time when he is going to be ruling on, probably right now, reviewing final drafts of orders, majority opinions, maybe dissents, maybe concurrences, in these major cases that could scuttle some of the very charges against Donald Trump, this immunity issue, this statutory issue, also making decisions about whether or not literally hundreds of people who were charged by the DC U.S. Attorney's Office, suffering prosecutions to this point, some of them spending times in prison, whether that action is also legitimate. He is deciding all of that. I'm going to talk more about why the flag is important, why the ethics issues are important, and then delve deeper into Sam Alito, who should no longer be on our United States Supreme Court.
This is Amicus, a law review. This is our weekly weekend broadcast discussing all things law and government and rule of law related, the administration, the delivery of justice in our nation and beyond, talking as the first component of our syllabus on this busy weekend, this Memorial Day weekend, when we celebrate the good and important things about America, and especially the ultimate sacrifices made by our soldiers, women, and men throughout our history to preserve the basic trappings of the rule of law and of justice, and of the ways in which government should properly work. Their sacrifices, as we all well know, as we commemorate, as we celebrate this weekend, the legacy that they have given to us by virtue of laying down their lives, those kinds of things now implicated by the United States Supreme Court, with people like Sam Alito,
who express contempt for those very systems and express cynicism for the mechanisms by which government does indeed work. Talking about beginning with this story, these repetitive stories about flags being flown over his home in Alexandria and again on the coast, signaling plainly his support, his biased support for the notion that the 2020 election was stolen. We know that with respect to this second flag, the so-called appeal to heaven flag, it comes from a 17th century philosopher. His name is John Locke. You have all heard of him. He wrote of a responsibility to rebel, even to use violence, to overthrow unjust rule. It is a paraphrase for trial by arms. That is appeal to heaven. That's what's on this flag. It also has a tree on it. The main point is that there's no appeal. And there's no one else who can ask for help or judgment except creatures, visionaries, spiritual entities who are in heaven. That's the last thing we can hope for, is that there'll be a divine intervention, an appeal to heaven to stop what's going on here on earth. That's the notion behind the use of it. Now, significantly, the appeal to heaven flag is one of three that is right now on display outside of the home, or the office rather, of House Speaker Mike Johnson on Capitol Hill. And there it may be viewed as less offensive, less problematic, just because Mike Johnson is a political person. He's a political character, and he can express those views, but not from a Supreme Court justice who is supposed to be impartial, especially at a time when this particular Supreme Court justice, along with 8 others, including the Chief Justice, is presiding over cases and is going to be issuing decisions in the coming weeks on issues related to the 2020 election and the legitimacy of prosecutions under it. A huge problem in terms of ethics and propriety and bias by our Supreme Court. So what has been the response to that? Well, there is public outrage, obviously, lots of editorials, lots of commentary about this. What has been our government response? Well, up to this point, again, Sam Alito has gone quiet on this after his initial statement that his wife was responsible for the upside-down flag in Alexandria. We have not yet heard from the Chief Justice, which is sort of the point about the next development that happened late this past week, and that is that Richard Durbin, who is a senator from Illinois, he also happens to be the chair of the Senate Judiciary Committee. We've talked a lot about him in the past because he was one of these folks who, along with another senator named Sheldon Whitehouse, he's a senator also from on the Senate Judiciary Committee, have been advocating for a combined and composite and compelling set of ethics, an ethics code for the Supreme Court. Unsuccessful in getting that done. The Chief Justice, even in the midst of their advocacies across the parking lot in the Congress, issued an amalgam, if you will, of standards by which the Supreme Court is supposed to act, but not a code of ethics. Interestingly, though, that code of non-ethics, which the Supreme Court justice did in fact issue last year, does contemplate that this very kind of thing that we're talking about is forbidden. Among other things, that compendium principle says employees of the Supreme Court may not engage in nonpartisan political activity if the activity could reflect adversely on the dignity or impartiality of the court, or if it interferes with official duties. Hard to imagine a more clear violation of that standard, short of a code of ethics, but nonetheless articulated by the Supreme Court a number of months ago. Dick Durbin continues to advocate for that omnibus code of ethics that would prohibit this kind of thing and presumably would involve some sanctions if indeed you violate that code of ethics. Now, early on, after the first flag issue surfaced through the New York Times, Dick Durbin said, you know what, I'm not inclined to do anything. I'm not inclined to have hearings. I'm not inclined to go down that road at all. When the second flag, the flag that again is appearing at the beach house along the Atlantic coast, when that second flag, the appeal to heaven flag, appeared, apparently he changed his perspective and said, no, we need to do something. And I would offer this morning the something is fairly tepid. He writes a letter on May 23rd, late this past week, May 23rd, 2024, addresses it to the Chief Justice of the Supreme Court. His name is John Roberts, as you well know, and describes, again, the facts, the news stories about these flags flying, and the fact that while these flags are flying, they indicate not only the positions, the political positions of the Associate Justice, Sam Alito, on these matters that are pending before him right now while he's on the court. It also goes on to say this: the rule of law is founded on elemental propositions, including the collection of evidence by investigators without an interest in the subject of investigation and the use in the investigation of statements whose falsity would be sanctionable. The rule of law is also founded on the ancient principle that no one is a judge in their own case. The letter goes on to say, for centuries, Supreme Court justices conducted themselves in such a way that the absence of proper procedures consistent with these principles was a moot failing. That is no longer true. The court's code of ethics has failed to address or prevent any of these ethics violations, again, identifying those of Associate Justice Sam Alito, largely because it contains no enforcement mechanism. Both the court and the Judicial Conference, that's the Judicial Conference of the United States Courts, appear to have failed to even investigate allegations of ethics violations by Supreme Court justices, much less provide any findings or sanctions. And here is the rub. This is the request that was issued by, again, Senator Whitehouse and also by the chair of the committee, Dick Durbin, just this past week, a letter written to the Chief Justice asking for this. Here's the ask. We therefore call for Justice Alito to recuse himself from certain proceedings as outlined above. Again, this is a 4-page letter, lots and lots of information, predicate bases for this request. We renew our call for the Supreme Court to adopt an enforceable code of conduct, which they have not done, for all Supreme Court justices. And then we request a meeting with you as soon as possible. Until the court and the Judicial Conference take meaningful action to address this ongoing ethical crisis, we will continue our efforts to enact legislation to resolve this crisis. Again, the chair of the Senate Judiciary Committee calling upon the Chief Justice for the recusal of Associate Justice Sam Alito with respect to these cases that are pending in front of him, calling for an enforceable code of conduct, which also has not happened. The Chief Justice plainly not going down that road at all, and requesting a meeting. Let's sit down and let's talk about this. Well, it's a good first step with a very small G in line, but it's not enough. It plainly is not enough. What that meeting will look like, what it's supposed to be, what the accomplishment coming out of that meeting, it's unclear from the letter, but presumably some kind of discussion about these issues that are described as a crisis, and we're having a meeting about it in Washington, D.C., between branches of government that do indeed check and balance each other. That's what the Constitution is all about. And I would offer that as much as I support Senator Whitehouse and Senator Durbin for doing just this, it is not enough. And in the wake of all that has happened, especially in the wake of other things that this Associate Justice has said and done in recent years, it requires more than just recusal. Recusal is the lowest response to this possible. He's got to recuse himself. He should no longer be presiding over these cases. And the advocacy coming out of our weekend broadcast is that Sam Alito, because of his contempt not only for the systems that he has revealed in his writings, his conduct, and yes, in these flag displays of recent times, can no longer be on the Supreme Court. Let's talk about that. Let's talk about the reasons why I'm advocating for his resignation from the Supreme Court of the United States of America. Let's go back and talk about his contempt, not only for apparently the voting system, the polling system that produced the 2020 election results, a system that plainly he disregards, he feels is discredited. He has plainly indicated to that clearly and unequivocally, almost putting aside his conflict of interest. He has contempt for the very system that elected the present president of the United States of America, presumably other elections, past and perhaps future, coming up in just a few months from now. And by virtue of flying those flags, the upside down United States flag, and also the other flag outside of his beach home, he is indicating that the recent election was stolen. It's not to be credited. Do not believe that election. The voting, the elective process that produced the results that were announced by the Congress on January 6th resulted in the swearing in of President Joe Biden on January 20th. None of that is to be believed because that vote was in fact stolen. That is what he is telling us by virtue of flying those flags, again, over and above the problem that he now has in presiding over cases in which that very issue is at stake. But there is more. Let's go back. Let's talk about other things that Associate Justice Sam Alito has said and done that also reflect this cynicism, this contempt, even this conspiracy view that he has about many things in American history. We know well that the Supreme Court has issued at least two other cases involving voting rights under the Voting Rights Act of the 1960s. One of those, of course, Shelby County, which basically eviscerated Section 4, Section 5 of the Voting Rights Act, a pre-clearance provision. And he also the Supreme Court issued on July 1 of 2021, a case called Brnovich. This is also kind of the companion case in voting rights litigation and decision-making of recent times. It had to do with a couple of statutes that were enacted by the Arizona legislature. One of those says that if you, in fact, you vote at the inappropriate place, your vote cannot be counted. The other one says that if your vote was a part of a gathering together of a number of votes before they were delivered to the people who count those votes, likewise, those votes can't be counted. And the Supreme Court in this case called Brnovich versus DNC found that under Section 2 of the Voting Rights Act, that those kinds of limitations, those restrictions on counting properly made votes can in fact survive the voting rights scrutiny. And so they proved that. And along the way, Sam Alito, writing in that case, again back in July of 2021, articulated a number of standards for the legislatures, local municipalities, county, state, and federal legislatures to adopt, to follow, when it comes to deciding whether or not particular restrictions on voting can in fact be imposed. And he described 5 in particular, all of them suggesting that if in fact the impact upon voting is de minimis, if there are a few people, even groups of people who are disenfranchised, doesn't mean that much. He says the size of the burden imposed by a challenge voting rule is relevant. In other words, if it doesn't have much of an impact, doesn't matter all that much. He says the degree to which a voting rule departs from what it was standard practice, that also is maybe a relevant consideration, but also may not suggest that the voting restriction is inappropriate. He says the size of any disparities in rules impact on members of a racial or ethnic group. Likewise, it's important, but if it's not significant, we can disregard that too. And he also says that courts must consider the opportunities presented by the legislature, by the state generally in the voting system. If there are many other things that enable voting, those too can overcome problems in voting. Finally, he says, and here's the rub, he says that the strength of the state interest served by a voting rule is also an important factor. And here is the language that expresses cynicism about fraud in our elections and suggests that he believes this is in the law, this is in the decision of the Supreme Court of a number of years ago that basically codifies, for the first and as far as I can tell, only time, the notion that indeed fraud exists inside our voting systems. He says this: one strong and entirely legitimate state interest is the prevention of fraud. Fraud, he writes, can affect the outcome of a close election, and fraudulent votes dilute the right of citizens to cast ballots that carry appropriate weight. Fraud can also undermine public confidence in the fairness of elections and the perceived legitimacy of the announced outcome. I'm going to talk more about what that means and why, once again, it shows the cynicism of an associate justice about the very systems by which we vote in America, as Amicus, a law review, continues here in the broadcast stations of Civic Media.
There is a caller.
Okay, good. I will probably, could you let her know? I'm going to finish up this. If she can hang on the line, I'm going to take her probably at the top of the next hour. If you could tell her that, that'd be great. This is Amicus, a law review. My name is Jim Santelle, talking all about Sam Alito. Talking, yes, that's right, in very serious tones, very serious words about the cynicism and contempt of Associate Justice Sam Alito, going back to this 2021 decision in Brnovich, a voting rights decision in which he codifies in the law of our nation, in this opinion of the majority of the Supreme Court, written by Sam Alito, that fraud exists. That fraud exists in our election processes, and for that reason, legislators who are responsible for ensuring that our votes, our voting system, our polling is proper and conducted in a way that's consistent with the law, they should be concerned about this fraud that is out there. Fraud can dilute the right of citizens to cast ballots. Fraud can undermine public confidence. And be careful about that fraud, is what he's telling us. And he's codifying in that law of the United States of America. Brnovich is the law of our nation, something that has never been codified before. And as far as I can tell since then, that we should be concerned about something that doesn't exist. He is telling us, consistent with those flags flying over his homes, his beach home, and also his principal residence, that indeed elections in America are being stolen. And they're being stolen by people who are committing fraud, and that you need to be scared of it. And that, once again, is a basis for the advocacy for him to remove himself from the Supreme Court. The cynicism about our very election system, the polling system by which we elect our elected representatives, as established in Brnovich and in other ways, cannot be tolerated. And it indicates a bias far beyond just the flying of those flags and the specifics about the 2020 election. This is a Supreme Court justice in the top position in our judiciary saying that our elective systems are subject not only to review, which they can be, but are also rife with fraud. And for that reason, be careful about, be doubtful about, be suspicious about the results of our elections. That's what he is telling us in Brnovich. There's more. Let's talk about what he wrote more recently in June of 2022, just a couple of years ago, coming up on the anniversary, of course, of Dobbs versus Jackson Women's Health Organization. And here again, an awful lot of analysis that precedes this particular writing of his in the decision on behalf of the majority in Dobbs. He says that the right to abortion does not fall within the category set forth in the Constitution. We hold that Roe and Casey, which of course are the previous rulings in this area, that establish that indeed there's a privacy right, that the Constitution, he says, makes no reference to abortion. No such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. All of that, again, articulating a view that is contrary to what the Supreme Court had said for about 49 years up until that time. What he says, and the reason why this particular language that I'm about to recite is also so compelling, also expresses a contempt for the very court on which he sits. Way back when the decisions in Roe and Casey were decided by a Supreme Court, yes, that reviewed the status not only of medical treatments and conditions at that time, but also the status of the law. That was the decision of the Supreme Court. Here is what Sam Alito says more recently about the decision in Roe and also Casey. He says Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And far from bringing about a national settlement of the abortion issue, Roe and Casey, by the way, written in part by Sandra Day O'Connor, have inflamed debate and deepened division. It is time to heed the Constitution. That's what Sam Alito writes a couple of years ago, suggesting once again that his predecessors on the Supreme Court, with whom he disagrees, he can do that. Supreme Court justices and courts overrule these kinds of things all the time. But when he says that, he basically says that the Supreme Court is itself not legitimate. It is time to heed the Constitution, which plainly my predecessors on the court did not do. Roe was egregiously wrong from the start. They got it wrong, and now I'm here to correct that. I would offer to you that is contempt for the very processes by which our courts are conducted and the legitimacy of the Supreme Court itself. And then there's more. And we have talked a bit about this, and this happens a month ago today. The Supreme Court entertaining argument on this immunity issue, on this all-important immunity issue, deciding whether or not a president can indeed commit crimes while he, or one day she, is in the White House. Here's what happens during the course of the oral argument on this case involving immunity. Justice Sam Alito suggests that there are not legal safeguards in place to protect presidents against malicious prosecution absent some form of immunity. Okay, he's sparring with the other justices, at least 3 of them on the bench, maybe not all of his colleagues there. He tells the prosecutor, he tells the counsel, his name is Michael Greben for the Solicitor General, that the grand jury process doesn't work. The grand jury process in America does not work. It's not a protection, he says, because prosecutors and grand jurors, as Sam Alito is saying from the bench of the United States Supreme Court, can indict a ham sandwich. That's what the Associate Justice said from the bench of the United States Supreme Court a month ago. No respect for the grand jury process, which again is not, for what it's worth, it is not an entity of the executive branch. It is not an entity of the presidency. It's an entity of the courts. It's his own system. The grand jury system, not a protection, because a grand jury and prosecutors along with them, apparently also corrupt, can indict a ham sandwich, using that phrase that's way too overused. And when counsel for the government pushes back and says, no, grand jurors do their work in a competent and thoughtful and reasonable way. And it's his experience, as it has been mine for 30 years of my own work with grand jurors and other prosecutors. They often don't indict people who don't deserve it. Why? Because the facts aren't there, because the law isn't there. It happens all the time. Grand jurors do their jobs well. And what is the response from Associate Justice Sam Alito to that notion that he is wrong about the illegitimacy of the grand jury process, that jurors who are pulled from our public groups and our public populations do their jobs competently, as do prosecutors? His response is, well, dismissively, he says, every once in a while, there is an eclipse too. Every so often, he says, maybe prosecutors, maybe grand jurors will get it right. That is contempt unbounded. That is cynicism for the very systems of government that he is required to uphold. That's the oath of office that he was mandated to uphold as a Supreme Court justice. Cynicism unbound, in addition to the flags, in addition to these statements in Brnovich about how we've got fraud in our systems, and legislators should be wary of that fraud. Americans should know that there is fraud in our elective politics and our elective systems, and they should know that the results of our elections are therefore compromised. The notion that the Supreme Court itself is not legitimate, and indeed that the grand jury process and prosecutors are corrupt. All of that a part of the cynicism, and I would offer to you as well the contempt that this Associate Justice shows. In our second hour, we're going to talk more about this and taking your calls and your comments as well right here on Amicus, a law review.
So everyone's calling about the same thing.
Okay, very good. All right.
The three. The top person, Kristen, she seemed pretty civil.
Right.
The Mark guy, he seemed pretty civil. The other guy seemed a little like angrier.
Okay.
I don't know if that's
sure, that's fine. We'll take Kristen. We'll do Mark then, and maybe I'll get to John. We'll see. I think I've heard him from before. Yeah.
Okay.
Yeah.
Sounds good. Well, because John was first.
Okay.
It was in order there.
Okay.
So.
Okay. So it's Kristen, John, and Mark.
Yep.
Okay. I'm going to probably not call upon them in that order. I may do Kristen first, Mark, and then we'll go to John.
Just say it so I know.
That's good. Yep. Absolutely.
We got about 4 or 5 minutes.
All right. Very good. Good.
So.
Welcome to Amicus, a law review with Jim Santelle. Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus Law Review. My name is Jim Santelle, and yes, I'm your host for this, the second hour of our weekend broadcast, focusing a huge amount appropriately on the conduct, the recent activities, the words, the speech of Associate Justice Sam Alito, plainly in the wake of his flying of these flags that express his view explicitly that he feels that the 2020 election was stolen. Support for those people who advocate for that position, a position that has been rejected roundly, soundly, decisively by every single court that's addressed this, and an associate justice who is right now deciding cases that go to those very issues about the legitimacy of the 2020 election. 2 cases coming up for decision. An awful lot of advocacy out there for his recusal. Take yourself off those decisions while you have exhibited this bias toward a particular position on the legitimacy of the 2020 election. That's appropriate. That is highly appropriate. It is not enough. And that's the advocacy of this weekend's broadcast. We know that in addition to his apparent contempt for what happened in the 2020 election, his cynicism about the results of that time expresses equal cynicism and contempt for things like the fact that fraud is rampant in our system. He writes that in the 21 decision in which he says Americans should be concerned about the fraud in our elections, and legislatures should craft their responses to that, understanding that fraud exists, and it does not. And there, once again, he expresses to America, through the law of the United States, codified in this case called Brnovich, the notion that we have fraud in our elections, and that voting is suspect, and that you should not trust the results of what happens. That's number one. What else does he have contempt for and a sense of cynicism about? He's got cynicism about his own Supreme Court. He suggests that the predecessors on the bench 49 years ago, people like Harry Blackmun and indeed Sandra Day O'Connor, when they did a legitimate, obviously controversial, but an analysis of the privacy rights of the Constitution, not only got it wrong, but were doing so in violation of the Constitution. He is suspect of the history of his own institution, even more compelling than that. He is suspect of the very processes that are part of the court system. He tells us a month ago that he does not trust grand jurors. He does not trust the processes of prosecutors. He doesn't trust any of that grand jurors every so often might get it right, but most often they're indicting ham sandwiches. And once again, the grand jury, a system of the courts, not the executive branch, that's him. That's the Supreme Court. And he expresses nothing but contempt and cynicism for that process as well. Every so often, he says they get it right, as often as when an eclipse happens. That is an associate justice of the Supreme Court saying and writing those things in recent years. The question then is whether or not he should continue to serve, given not only his recent obvious statements about the 2020 election, but also these other issues related to cynicism and contempt for the very systems of government for which he is responsible in part, and on which he is deciding major issues. That is the question. That is the question before America. Should that person continue to serve on the United States Supreme Court? And for answers to that, hopefully in all directions, I turn to our listeners, our callers. We appreciate, again, views in all directions on what is admittedly a crisis, as at least 2 members of our Congress have indicated, asking for a meeting with the Chief Justice, asking for recusal, asking for a meeting to talk about all this. Good first step, not enough. Let's go to some of our callers who may have reactions to my advocacy for the resignation of Associate Justice Sam Alito from the United States Supreme Court. Let's begin with Kristen. Kristen from Waukesha, thanks so much for being with me this morning. How are you this morning, Kristen?
Hi, Jim. I'm doing great. I am just so thankful that you are taking such a strong position on this. I think the way you laid out all the reasons that he should be recused, or not only should he recuse himself, but he should step down from the court, is the clearest and most comprehensive list that I've seen were. And I really hope that the listeners share the podcast make any kind of a decision that is uh, unbiased when clearly this is all about Donald Trump. None of the other Republicans brought their cases all the way to the Supreme Court and said there was fraud. I should have won. Only Trump. So yeah, it's unbelievable. I thank you for doing this. I think we all need to do whatever we can to raise this issue until it can't be ignored.
Kristen, I thank you so much, not only for those supportive words, but more importantly, your sense as we digest this together as a community, as a nation. There's actually more out there that I'm not reviewing here on our weekend broadcast, more about what he has written and what he has said that, again, it goes far beyond this issue related to flags. It goes beyond all of that and defines who he is. And as you, I believe, have appropriately said this morning, I plainly concur in your view as well. It reflects on someone who is given responsibility for deciding what the law is and who plainly has a contempt, regardless even of the substance of how he resolves these cases. Resolves cases involving privacy rights and voting rights. He distrusts the grand jury system. He distrusts prosecutors. He distrusts voting. He distrusts polling. He dismisses and is contemptuous of these basic things which are a part of our democracy, our republic. And I would offer that they're contrary to the very oath that he has taken to support and defend the Constitution of the United States of America, the separate oath that he takes as a Supreme Court justice to abide by the law and to bring to his analysis an unbiased and unvarnished view of the facts and to apply the law to the facts as he may find them. We're going to talk more about that when it comes to the case out of South Carolina in just a few moments. Kristen, appreciate very much your thoughts and your advocacy for more of the discussion about this far beyond just flags. Let's talk with other callers this morning. Mark, you're calling in this morning. Mark, glad to have you with me this morning as well on Amicus. A lot of you.
Yeah, thanks for taking my call, Jim. Yeah, I'd point out to Sam what both the Fourth Amendment and the Ninth Amendment to the Constitution. The Fourth gives us rights to speech, secure, on persons. And the Ninth Amendment actually says that there are certain rights that people hold that are not enumerated in the Constitution. And one of those rights would be the right to privacy. I would uphold it simply under that language. And as far as abortion goes, abortion was common in the late 18th century and early 19th century America. I mean, it wasn't a question. It just happened, and there was no laws banning it. And under the English common law, which is supposed to be is part of the ultimate basis of our law, there's no establishment clause of religion as well. And so the San Benito was relied on Catholic doctrine, quoting edicts from the Pope about colonization. This is just a sign that he is completely out of touch with what the founders actually intended on a constitution. They intended on a secular democracy, expanding the rights of people and individuals to govern themselves. I mean, his Hobbesian view of society that we need a strong hand at government, and we're not supposed to trust what the people want at all, should be anathema to every American.
Right. And that notion, Mark, of trust that you identify, anathema to Americans, yes, that's exactly the point, right, that you're sharing. And when you discuss all of the issues that are properly before the Supreme Court right now, it's about trusting fundamentally in the institutions and Americans having trust in our Supreme Court. They can have that trust. They should have that trust. I've had that trust throughout my entire life. I suspect you and other callers, listeners have had that same trust based upon the notion that while we may disagree with them on particular issues across the board, they take up a lot of different things these days. Fundamentally, we know that at the core, they've got the interests of America. We can trust them to be concerned about and focused upon the best interests of America. That's my advocacy this morning, that is no longer the case when it comes to Sam Alito. We can make distinctions with other Supreme Court justices. We may say we disagree, agree with them on those issues. This isn't a Supreme Court justice who has shown contempt for the basic trappings of government, even as he applies those and uses those to come to the results that you're describing. So again, appreciate very much, Mark, your comments and your calling in this morning as well. We have another caller. John, you're calling in as well. Appreciate your being a part of our discussion this morning. John, your comment or question?
First of all, thank you for taking my call.
Absolutely.
Clearly, Alito, by stating his
unsubstantiated by any evidence that he could have the justice be using for making such a conclusion. So stating his belief that there's reason to distrust the results in our election system is illegal. It's simply encouraging the distrust of our election system.
Yes, yeah.
To paraphrase Justice Goebbels, the first minister of propaganda, if you tell the same lie often enough, it becomes true.
Right.
Now, as far as corruption in the court is concerned, as far as I know, there's no constitutional reason for federal judiciary appointments being lifetime. I believe the provision says it's for terms of good behavior, and traditionally what that's meant is that the only way to get rid of a federal judge of any kind is to do impeachment.
Right.
But shouldn't there be another way to
All right. All right.
The president can appoint them if he's the boss.
Right.
Theoretically fire them.
Mm-hmm.
Of course, that would set up, a constitutional crisis between the administration and the judiciary. But I agree, it's better. I'd argue that it's better done now than when the obviously corrupt so-called justices continue to ignore the Constitution.
Right. And yeah.
Legislative laws.
Right. And interesting, John, there in addition to the constitutional provision, this good behavior provision that anticipates lifetime tenure, Sheldon Whitehouse, again, signing this letter asking for a meeting. And yes, there should be more than a meeting, right? There should be much more than a meeting. He has also authored some legislation that would establish term limits for justices. Sounds unconstitutional, but his concept is, under this legislation, getting nowhere in this Congress, is that there would be term limits, 15-year term limits, and after that, we would not strip them of their status, but they move on to sort of an emeritus status, continue perhaps to preside over circuit court cases, do other things. But in the future, that those terms would be limited and provide more accountability. And you could address, with respect to present nominees and future nominees, whether or not they are committed to the basic trappings of our nation. We're going to talk more about all of this as our weekend review here on Amicus, a law review, continues, and also talk more about Sam Alito and his authoring on behalf of the majority, a major opinion coming out of the Supreme Court just this past week. Is that Kristen? Do you think it's the same Kristen as before, or a different Kristen?
I think it's the same. I think it's the same one.
Okay. All right.
Do you want to take them?
Sure. Yeah, I'll take her, and then I'm going to move on to something else here.
Right.
Good. That sounds good, Sam. Great. Good. And John, right, John was pretty good, right? I was actually girding my loins for, okay, here's the attack, right? Yeah, but he was okay. All right. So thanks.
Because that's what he sounded. We kind of sounded like that when he called right away.
Yeah.
Like, it could be a little interesting.
Right. But that's good. We like interesting, right? Right. This is Amicus, a law review. We are spending much of our time this weekend talking about Sam Alito. Yes, the flags issues, which revealed his bias when it comes to issues pending before the Supreme Court right now, but also talking about his recent history of contempt for everything from voting in America, subject to fraud regularly, such that he puts it in an opinion of the United States Supreme Court. Contempt for the history of his own court, suggesting that predecessors in his position and the positions of others operated unconstitutionally, and that their misbehavior, their misconduct has to be remedied now, as he did a couple of years ago, focusing most recently upon this notion that somehow prosecutors and grand jurors, arguably even trial jurors, are not appropriate, and that they engage in their behaviors in a way that does not accomplish justice. Contempt for the basic trappings that he himself is responsible for enforcing, and for that reason advocating here this weekend on our broadcast that there be more than a meeting. Appreciate very much the effort and value and support the meeting concept. More than a meeting, maybe there should also be some testimony before a hearing of the Senate Judiciary Committee. Perhaps let's do something else unprecedented. Let's go ahead and subpoena Supreme Court justices to come across the parking lot there on Capitol Hill and subpoena the Chief Justice to come in and explain what's going on ethically before the Supreme Court. Subpoena Sam Alito to come and explain how, on the one hand, he can fly these flags and articulate these things while at the same time purporting to be unbiased and have a neutral view on these kinds of things. Done before? Nope. Unprecedented. And yet we talk a lot about all the unprecedented things happening. See if the Supreme Court would accept, number one, the invitation, non-subpoenaed invitation to come and appear before the Senate Judiciary Committee, even the House Judiciary Committee, if they would really be interested in exploring these issues. And if not, seek to enforce those subpoenas in the federal district court there in Washington, D.C. See if that would go. See what would happen if you attempt to enforce a subpoena of a Supreme Court justice in the role, your oversight role, your check and balance role as a co-equal branch that is the Congress and the Senate of the United States of America. Lots of things that can be done here. A meeting has been invited. We'll see what the Chief Justice, how he responds to that. Probably highly unlikely that meeting is going to take place. No testimony, no subpoena, no recusal, no removal, none of this. And thus the outrage of the American population as we look to a Supreme Court that is deciding right now these major issues and wondering aloud if that Supreme Court, and this is the point, if that Supreme Court is credible. Should we trust the Supreme Court when it expresses this hostility, this cynicism about the basic trappings of our government? Why should we follow those decisions? And we should. That's the rule of law in America. That's kept us animated for 240 years. But why should we do that if indeed the very justices who are telling us what the law is, they themselves are not in support of the basic trappings of our Constitution and our government? That's the question. That's the question that as we head into this election season, all Americans should be asking. That's the question that should focus upon Sam Alito and ask him about what his next step is in the midst of his disbelief in the fundamental structures of our government. Kristen is on the line and would take Kristen's call as well. Kristen.
Hi, this is Jean from Eau Claire.
Yes, Kristen. Thanks so much for being with me this weekend.
This is Jean. I just want to call and say thank you for this show. I have never seen it laid out so well. You know, in a sense, Alito has proclaimed himself, you know, as the decider on chief. He really has, by the proclamation that he has made, laid the groundwork for both psychologically and legally, totally, making one pathway for anybody to utilize the legal system, you know, to protect their rights by, running down the decisions of former justices. I mean, that have been there for years and years. People really need to share your podcast. It is so amazing, your show today, Jim, because it just lays out, because this is so dangerous, because by totally discrediting, all of the different legal avenues that a person has, and totally discrediting them, and then empowering legislatures to take away rights because of the fraud. I mean, thank you, James. They need to go, and they need to take this seriously, because this was the only avenue for the people to protect their democracy and their rights. So thank you, James. This is unbelievable, and we all need to have our voices heard and say no more, no more. There will be no more, because he has just proclaimed himself the decider of everything. Thank you very much, James. Appreciate it.
And Jane, I thank you. I appreciate your phone call in here. Again, on this broadcast and other broadcasts of Civic Media, we entertain and value views in all directions, and appreciate when others beyond me not only articulate their views, don't necessarily have to agree with me, but it is good to know that the messages here about this contempt, the cynicism, are falling on ears that are listening, and at least giving some critical thinking into all of this. And again, the major question implicit in what your comments are all about, Jane, is what do we do next? What do we do next? It is good, as I said, that there be a meeting of some kind. I don't know how that works. I don't know if that's a public meeting, a private meeting. That's what the leadership of the Judiciary Committee and the Senate have asked for. There needs to be more than that, right, Jane? There needs to be a hearing, a public hearing. The Chief Justice needs to walk across the parking lot and appear before the Judiciary Committee. He needs to explain what's going on, not only with recusals, appropriate recusals. He needs to explain what's going on with this ethics code, which has not been resolved yet. He needs to explain things about the integrity of the court. This is the John Roberts Court. He needs to appear there in that public setting to answer legitimate oversight questions of another branch of government. And if he doesn't do so, the Congress needs to enforce those subpoenas in ways that we have not done before. That is dramatic. That would be stunning to have that happen, but that needs to happen as well as a part of our system to ensure that going forward, not just this generation, future generations have trust in our Supreme Court of this land. Appreciate not only Jane and the other callers, but also people like Dawn Hall, who are also sending me some notes and questions. Appreciate Dawn, your comments and your questions also in this area of what our Supreme Court is doing and the integrity that they necessarily need to bring to their job on a regular basis. Let's talk about something else that Sam Alito has done just this past week, and that is this major decision. Yes, that's right. We're in the midst of this time in the Supreme Court's history when they're issuing major decisions in many cases. A major decision coming out just a couple of days ago, just this past week, May 23rd. The case is Alexander versus South Carolina State Conference of the NAACP. Yes, this is this major case that we have talked about before. It is the singular but critically important case on the docket of this Supreme Court in this term, talking all about the intersection between politics and race. And the question here is whether or not the South Carolina legislature, when it redrew what's called District 1 right along the coast in South Carolina there, did it do that for political purposes, which, believe it or not, in America today are proper, or at least not justiciable. Courts cannot review those things. Or did they do this out of a racial animus, in which case courts can review those decisions? Which one of these happened here? The Chief Justice and the other justices in the majority ruled this past week that this was all about politics, and this was not about race. And indeed, even though that was the case, the lines there in South Carolina will stay as they are. When we come back, talking more about that case here on Amicus, a Law Review.
Sorry, I couldn't understand her when she said her name.
Oh, that's fine.
All.
That's fine.
It was
No problem. That's good. That's not an issue. Not a big deal. If that is my hiccup today, that's
Yeah.
we're doing pretty well.
Oh,
So no,
that's
good. And you got the intro for the second hour. So is someone's there, or did it just happen? It happened to kick in this time.
It was there.
Okay,
it was
yeah,
there the
yeah.
first time I tried to play it. It wouldn't play
It wouldn't play. Yeah.
because it was on the cloud.
Okay, yeah.
How it works is it's on the cloud,
Sure.
so it's all
sure.
online,
Yeah.
but it didn't load. So when I tried to play it, it was trying to load it, not play it.
Got it. Okay. Yeah,
and then
yeah.
like this time, I made sure it was
Sure.
I literally played it before we actually played it on
right.
air to make sure. But
did
it was
a
there.
test run. Great. Again, I don't care that much about that, but it's good to have that. The music sounds a little bit better. Again, maybe I'll go back and pull up even more. I really want something that's almost cacophonous, right? Just like almost some harsh piano music or something. And maybe it's in that group or so. This is better than it was last week and earlier, but maybe we'll go back. But I think it's good.
I haven't played all of them yet.
Yeah. Okay. Good. But yeah, lots of good callers and on the edge today, but that's okay, right? Right. Very good. Right. Max, thanks so much. Appreciate it. Good. We'll do it.
In terms of time, I'm just gonna keep doing the same thing.
Yep.
And if I do like a slow rap,
okay,
that's just kind of get into the
finish it up, right?
But
yeah.
If I'm going like
this, then that's really we're coming to an end. Okay, and I appreciate this again. This is a minute, and this is always 30 seconds.
This is
right?
30 seconds.
So this is 2 minutes and 30 seconds, 3 minutes.
1:30.
Right.
Yeah, because with that last caller before on the last break, it was
He was right in the
It
middle
was,
of that.
right. It was
yeah.
3 minutes left, and I was like, I don't really know how long you're gonna go. So I'm like, I'm
Right.
making sure that I count you down
Got
too,
it.
so you're not like, oh my God, there's 1 minute left. This guy's still
Right, jabbering
yapping,
away.
yeah.
Right, yeah. Always have to cut off Mark too. Wow, he just every single time he calls, you think you're listening to yourself. You start here, you go over there. It's just 12 million things. I know he calls into other stations too, but boy, just unfocused and always supportive. But boy, just wants to hear himself, I guess, on the radio. So good. All right, we'll do another half an hour of this. Great. Thanks, Max.
Yep.
Good. This is Amicus, a law review. My name is Jim Santelle. Thank you for your continuing listening on our weekend program, talking once again about justice, the rule of law, government in our nation, and focusing now on this major case, one of many cases. Supreme Court's got about 36 more cases to issue between now, presumably until the 4th of July. Lots and lots of cases coming up here. We're going to be talking about all of them, and this plainly among the most important of those 36. They've already issued opinions in about 26 cases, some of which we have already discussed here on our civic media broadcast. This case, Alexander versus South Carolina, NAACP. Question of how a legislature works. The question there is whether or not the South Carolina legislature, in redrawing some maps in the wake of the 2020 census, and indeed in the wake of an election in which it became very clear that a Republican majority was waning in a particular district, the first district, when they redrew these maps, and in particular the maps of the first district and the 6th district as well in South Carolina, did they do that out of racial focus, racial purpose, in which case that, of course, is unconstitutional. That is subject to review in the federal and even state courts of our land. That, the Supreme Court has said, is justiciable. That's the kind of thing that can be taken up by the Supreme Court. But in another case called Rucco versus Common Cause, way back in 2019, the Supreme Court said, if you do gerrymandering based upon political motivation, You're doing this because of partisan politics. You want to ensure that my particular party, Republican, Democrat, another party, whoever you are, wherever you're affiliated, we want to make certain that we maintain control. That decision, that political decision, that partisan decision is not justiciable. That's the kind of thing that cannot be inside the courts. And the Supreme Court, again, with some controversy, ruled in 2019, they'll take up the racial gerrymandering challenges, but they will not take up the political partisan gerrymandering challenges. And so the question here is, who is right and who is wrong in describing what happened in South Carolina in recent years? The voting case, again, this matter coming before the Supreme Court, and the decision coming out of the Supreme Court is ultimately, as the Supreme Court ruled, that the South Carolina population, the legislature, will keep using a congressional map that the lower courts that looked at all this said, yes, indeed, this is racial gerrymandering. This is not principally partisan gerrymandering. The lower court had deemed this unconstitutional. This is racial animus, a racial gerrymander, the lower court had said. They said it resulted in a bleaching of African-American voters from a certain district, that's District 1. The conservative majority of our Supreme Court, led, yes, that's right, by Sam Alito. He writes the majority opinion on behalf of himself and 5 others, a 6-3 vote, returns this case to a lower court. There are more proceedings are going on, but plainly decides that indeed what has happened here is okay, allowing the South Carolina Republicans, the legislature there, to maintain boundaries that helped make this district in question a party stronghold, basically saying, yes, you can do this. And that's because we have determined, based upon our review of the facts, that this is not racially motivated. This is simply partisan politics. Now, lots and lots of things to unpack here. It is an extensive opinion, almost 40 pages. The majority opinion, again, written by Sam Alito. We've got a very interesting concurrence and quasi-dissent written by Justice Clarence Thomas, in which he suggests that maybe the 1954 decision in Brown and Brown 2, maybe too much enforcement going on there. Stunning coming out of any Supreme Court justice, but again, suggesting that he himself is not committed to the precedents of the Supreme Court. And then a very, very compelling, a very readable, a very digestible dissent, a scathing dissent from Elena Kagan, joined in by Ketanji Brown Jackson and Sonia Sotomayor, in which she basically says this: what the Supreme Court has done in its majority is to substitute its own views about the evidence for that of the lower court that had a trial, that entertained witnesses and documents. And that gets to the fundamental notion that she articulates, which is, under a clear error analysis, what the lower court determined, which is that there was in fact a racial gerrymander here, moving large populations around in a way that disenfranchised Black voters in South Carolina. That was the determination of the lower court based upon its in-court, its careful analysis. And at the appellate level, Supreme Court or other courts at the appellate level apply what's called a clear error standard. So a little bit of civics, a little bit of law school here, as we often do on this broadcast. The standard of review that appellate courts, including the Supreme Court, usually undertake when reviewing a trial court's findings of fact, that's called clear error. And it means just what it says. A review under this clearly erroneous standard is very deferential. We only overturn that as an appellate court if the decision on the facts is clearly, unmistakably in error. If the trial court's factual determinations are plausible, which is exactly what Elena Kagan says repeatedly as she goes through all of the evidence here, if it's plausible in light of the record as a whole, the appellate courts in our country, including the Supreme Court, may not reverse, even if the appellate court would have decided things differently. Even if the individual justices, even those on a panel of an appellate court, say, you know what, I might have viewed this differently, but we defer, there's that word once again, we defer to the lower court because they were there. They listened to the witnesses. They assessed credibility. They did all those kinds of things. And under the clear error standard, we should defer to those findings unless, once again, it is so absolutely ridiculous in terms of the factual findings that it cannot hold. When reviewing mixed questions of law and fact, That's when appellate courts use a clear error standard of review, when the lower court's decision primarily focuses on factual work, and a de novo standard of review when that decision involves primarily legal analysis. So we review things de novo under that definition when indeed there's a mixed question of law and fact, and you've got to review the law, what the law says, not when the facts have to be reassessed. And that's what Elena Kagan says principally in her dissent, which is scathing on behalf of herself and two others. She identifies once again that the parties agree that the South Carolina legislature wanted to make District 1 more Republican. Nobody disagrees about that. They further agree, she says, that in pursuit of that aim, the legislature moved nearly 200,000 people into or out of that district. What the parties disagree about, she writes, is how the people expelled from the district were chosen. The state, that is the legislature, she says, contends that its map maker looked exclusively at data, only at data from the last election, and targeted people who had voted Democratic. In other words, only look at partisan considerations. If that is true, Elena Kagan and even the others in the court say, the state's action, however unsavory and undemocratic, that's Elena Kagan saying, you may not like it, but that's the law today under this Rucco case of a number of years ago. Even if you don't like it, it's immune from federal constitutional challenge, and therefore we've got no case here. The challengers, that is the people who object to the way that this District 1 was restyled and remapped, that basically moved large black populations and large white populations around, was in fact done for racial purposes to diminish the impact of the black vote on racial grounds there in South Carolina. The challengers, she said, offer a very different account. They say that the map makers, not content with what the election data revealed, also reviewed and heavily relied on racial data, thus exploiting the well-known correlation between race and voting behavior. And if that is true, as Elena Kagan sets forth the understanding here, the challengers have a good constitutional claim because, and here we go, the Equal Protection Clause forbids basing election districts mainly on race in order to achieve partisan aims. And so the question is, what do we have going on here? What Sam Alito says in the majority is that we have here overwhelmingly, contrary to what the lower court said, what we've got here is partisan gerrymandering. That's okay. And so we keep our hands off. We're setting this back down for the lower court to address this pursuant to that finding. And in fact, there is no sort of entangling, if you will, of race and partisan politics here. The majority, written by Sam Alito, and this key ruling says they, the challengers, provided no direct evidence of a racial gerrymander, and there is circumstantial evidence, which again can be just as compelling as direct evidence. That's me talking, not Justice Alito. There are circumstantial evidence, he says, is very weak. Instead, the challengers relied on deeply flawed expert reports, again indicating that he's going beyond a clear error standard. We're going into a de novo review, if you will, of the facts, not the law, the facts, flawed expert reports. And indeed, he spends a lot of the opinion analyzing the 4 or so expert reports here and explaining why it is they're all wrong. And while those experts produced tens of thousands of maps with differently configured districts, he says, they did not offer a single map that achieved the legislature's partisan goal while including a higher map in District 1. In particular, makes reference to this District 1 as being problematic there. Faced with this record, we must reverse the district court. Even in our clear error standards on the racial gerrymandering claim, and he says we're going to talk about this in 4 parts, and it also underscores the very way in which he abandons this clear error analysis and said we're going to put ourselves in the position of being the trial court once again. We're going to set forth the appropriate legal standards, which, yes, indeed, does provide an awful lot of deference to the legislature. That's where you start out, and Elena Kagan and the others do not disagree with that. But second, he says, we're going to explain why the district court's factual findings are clearly flawed. Clearly flawed, he said, with respect to the circumstantial evidence. We're going to examine, he said, the 4 experts that the challengers presented. And finally, we're going to explain the district court erred by not drawing an adverse inference from the failure to submit an alternative map. And Elena Kagan in her dissent goes after that as well. She says, we're making things up now. The failure of challengers to say, here's an alternative map in a basic foundational contest to whether or not the line drawing is proper or not, all of that, a part of Elena Kagan's strong dissent. In the end, writing on behalf of a majority of the Supreme Court, Justice Samuel Alito, on whom we're focusing, and to whom, in many ways, we're dedicating our weekend show, this broadcast. Sam Alito finding, in again, here in this major case, that there's no violation of the Constitution, the Equal Protection Clause, no racial animus, no racial animation for doing what the legislature did. Why? Because what they did was all political. And that we will permit, that we will not review. In this case, it's all political, and therefore we never even get, if you will, to the racial issue, which may have been there, but saying that the challengers, the petitioners, the plaintiffs below, in the trial that was presented to a trial court judge who made just the opposite finding, this finding that indeed those votes have been whitewashed there in South Carolina, we're going to substitute our view of this evidence for the view of the district court and indeed of the lower court generally. That's what the majority of the Supreme Court has said in this major opinion. It is worth reading, is worth reviewing. Always advocate for that. Always advocate spending some time, even though it's a lot, especially on a Memorial Day weekend when we honor and we think with reverence about the sacrifices made for the very institutions that are at the subject of this lawsuit and of this decision. Even in Memorial Day weekend, would be good to pull this major opinion out and review it and make a determination on your own about whether or not the majority opinion that rejects the fundamental notions adopted by the lower court, that racial motivation was a part of this, and that people of color in South Carolina have been disenfranchised by virtue of the way that this District 1 and arguably District 6 was constituted, whether all of that makes sense to you. That should also be a part of your analysis on this Memorial Day weekend, as should a concurring sort of dissenting opinion that's also written by Clarence Thomas. And again, a lot of focus here as well. Clarence Thomas basically says, I would not even get into the analysis because, number one, the Supreme Court, courts generally, not only should we not be focusing upon this distinction between racial animus and racial motivation and political motivation, we shouldn't be doing this at all because we just can't do this. We can't do this at all. He advocates for a new standard that says the Supreme Court and other courts should be out of this business entirely. He's not a majority on that. But along the way, he also does something else. And that is he takes on, yes, that's right, Brown versus Board of Education. We will talk about what this justice of the Supreme Court said when we come back right here on Amicus, a law review. This is Amicus, a law review. My name is Jim Santelle, continuing our review, necessarily superficial because there's a lot to consume here, of this major decision just this past week by the Supreme Court finding that the decision by the legislature there in South Carolina to redraw the map with respect to District 1 disenfranchising some significant populations, voting populations of color, is permissible, sending the case back down with instructions that there is no problem here. The Supreme Court finding that by a 6-3 majority. Along the way, that 6 includes Clarence Thomas, and he decides not only should this case be sent back with an approval stamp on it, but beyond that, that the Supreme Court and other courts should be out of this practice entirely, should not be involved in racial versus partisan gerrymandering analysis along the way. And what he says is also stunning. This is, of course, the Supreme Court Justice who, not too long ago, in that Dobbs decision that we talked about earlier in this broadcast, also suggested that privacy rights should be back on the table when it comes to same-sex marriage and contraception. Let's revisit that as well. Now, just this past week, Clarence Thomas also says, oh, by the way, we should revisit the enforcement mechanisms in the wake of Brown 2, 1954, 1955, and years going forward. He says that at that time, Brown versus Board of Education, finding, of course, that separate schools, separate entities are inherently unequal, and they accomplish racial discrimination that our Constitution will not permit. He goes on to say this in his concurring opinion. He says, the court there took a boundless view of equitable remedies, describing equities as being characterized by a practical flexibility in shaping its remedies and by a facility for adjusting and reconciling public and private needs. Now that may be inscrutable, but what he says next is not. He says that understanding, again, talking about Brown versus Board of Education and putting into place, may have justified temporary measures to overcome the widespread resistance to the dictates of the Constitution prevalent at that time. But, and again, this is Clarence Thomas, as a general matter, such extravagant uses of judicial power are at odds with the history and tradition of the powers and the framers' designs. He's basically saying that the enforcement of Brown versus Education was too broad, over the top, shouldn't be happening. Extravagant use of judicial power, and recommending that perhaps we should go back, like he recommended in Dobbs, to revisit the issues related to privacy rights in the areas of contraception, same-sex relationships, same-sex marriage. Let's go back and revisit Brown versus Board of Education too, or at least the mechanisms of it that went way too far. Stunning for a Supreme Court justice to say that. Not the law of the land, thankfully, because this is in a concurrence, a bit of a dissent as well. But along the way, describing his own disagreement with the majority with respect to the breadth of their non-clear air analysis, but also saying that maybe we should go back along the way and look at Brown versus Board of Education too. In the end, I commend to your reading all of this, and I commend as well the reading of the opposing, the dissenting position articulated by Elena Kagan. It is compelling. And page after page, explaining why it is that the Supreme Court has set itself up as a trial court. What she says in the end is this, basically, go right ahead. She says, what a message to send to state legislatures and mapmakers about racial gerrymandering. For reasons I've addressed in the previous pages of her compelling dissent, those actors will often have an incentive to use race as a proxy to achieve partisan ends. And there it is, the proxy argument. And occasionally they might want to straight up suppress the electoral influence of minority voters. And then she goes on, this is Elena Kagan writing, go right ahead, this court says to states today, go ahead, though you have no recognized justification for using race, such as to comply with statutes ensuring equal voting rights. Go ahead, though you are, at best, using race as a shortcut to bring about partisan gains, to elect more Republicans in one case, more Democrats in another. It will be easy enough to cover your tracks in the end. Just raise a possibility of non-race-based decision-making, and it will be dispositive, according to the standards articulated by the majority. And this odious practice of sorting citizens built on racial generalizations and exploiting racial divisions will continue. That's what Elena Kagan said. In the electoral sphere, especially where ugly patterns of pervasive racial discrimination have so long governed, we should demand better. That's saying the nation, our nation should demand better. of ourselves, of our political representatives, and most of all, of this court. Respectfully, Elena Kagan says on her behalf and that of two others, I dissent. All of that commending to you this Memorial Day weekend for your reading and your digesting. It is a major case. It is one of 36 more that are going to be coming up in the weeks just ahead between now and when we celebrate the next major holiday in our national history, and that is, of course, our Independence Day on the 4th of July. This weekend, we memorialize, we commemorate the deaths, the losses, the sacrifices made by soldiers throughout our nation's history. Who committed their lives, laid down their lives for the principles that I would offer Elena Kagan is identifying today. The notion that voting is important, that voting is meaningful, that we do not have fraud in our votes, at least now in the early part of the 21st century, that our systems of government are right and accurate and they're worth defending. And yes, with respect to those people who laid down their lives, they're worth dying for. That's how important these things are. That our Supreme Court should be a body, a tribunal that understands that, embraces that. And then when it comes to voting rights and all those other things, incredibly important issues for all of us to understand and embrace. And that applies not only to the Supreme Court justices, but to all of us as well. And that includes, in our final minutes here, our callers calling in. Tony calling in. Tony, appreciate your comment as we begin to conclude our weekend broadcast. Your thought or comment today?
Well, I just had a question. I was listening to another show earlier this week with Lynn Kirshner.
Yes.
Another.
Former assistant U.S. attorney, just like me. Yes, exactly.
Yes. And he mentioned a site where you could write to the Supreme Court justice.
Sure. And you know what Tony, appreciate. Yeah, absolutely. So what we're going to do is we're going to put that sort of on the Civic Media website here. I'll tell you all about that. I'll give you a couple of options, not right now on the air, but we'll also give those to you directly. And we're going to talk more about what you do in the wake of all of this in our broadcast of next week as well, as we talk about how we respond, not only to the decision here coming out of the Supreme Court in South Carolina, but also talking about these larger issues. We'll get that information to you so that you can be a part of our process, which is also America, which is what we celebrate, this institution of our United States. I thank you so much for joining me this weekend. Look forward to your continuing involvement, discussion in our future broadcasts right here on Amicus, a Law Review, broadcast stations of Civic Media in Wisconsin and in other places of our nation. Have a great week, everybody.